5 seconds to go. Start. The submissions advanced by Shri P.S. Patwalia are to the effect that the judgment and order of this court dated 20th April 2022 has not been complied with by the respondents. The respondents ought to have taken back the appellant in service and thereafter proceeded to take the decision as directed by this court. Further, it was submitted that it took almost 2 years for the respondents to take a fresh decision. During this period, the appellant has neither been reinstated in service nor been paid any salary. No arrears have been paid from 17 December 2009, the date of the earlier termination order, even though the same had been set aside by this court. It was also submitted by Mr. P.S. Patwalia that this court, in all its humility, had not quashed the decision of the full court, but having given serious thought to it, had clearly observed that this court was of the considered view that the full court of the High Court of Punjab and Haryana needs to reconsider this matter, which in itself is a clear indication that this court had expressed its view on the resolution of the full court regarding termination of the appellant's service to be not sustainable. It was thereafter that this court had set aside the judgment of the High Court dated 25th October 2018 and the termination order dated 17th December 2009. It is also submitted on behalf of the appellant that the RPC and also the full court of the High Court have simply reiterated their earlier resolutions, and as such there has been no reconsideration of the matter. The resolutions placed on record are also non-speaking. It is also the submission of Mr. Patwalia that the complaint against the appellant was given by his wife and his mother-in-law. The entire contents of the reports submitted by the district and sessions judge and also the administration judge and the review committee are based on the complaint made by the wife and his mother-in-law. No independent inquiry was conducted, nor any show cause notice was issued to the appellant calling upon him to give a response to the complaint made by his wife and mother-in-law. It was also submitted that the main allegations made by the wife and mother-in-law relates to the appellant carrying on an illicit relationship with the lady judicial officer. The other complaints alleged were of residing outside the official accommodation and of using a private car which did not belong to him. It was also alleged in the complaint that the appellant had threatened and assaulted his wife. All the other allegations, apart from the main allegations of illicit relationship with the lady judicial officer, were linked to the aforesaid main allegation. The High Court on the judicial side in the case of the lady judicial officer found that there was not even any remote evidence regarding their illicit relationship and that the statement of the wife could not be taken as a gospel truth to throw the said lady judicial officer out of service, and it was found to be totally unjust. The findings recorded by the High Court in the judgment dated 26th October 2018 with respect to the illicit relationship is reproduced hereunder. At the outset, we are at a loss to find even remote evidence about any illicit relationship from the above except use of the word illicit relations. That apart, her mere statement perception like a gospel truth could not be acted upon to throw the appellant out of service. That was totally unjust. Stop.